Anybody who has any doubt, my lord, I want to say it here in public, that for the purposes of this court and the purposes of this application, this court has no option but to take that judgment as granted. Even if your lordship read the judgment and said, I've never seen any judgment so bad, there's nothing you can do about it, there's nothing I can do about it, and there's nothing anyone can do about it.
So just on that point, can we clear up an ambiguity in the papers about the effect of the application for leave to appeal?
Yes, my lord.
Is it your case that the filing of your application for leave to appeal suspended the operation
Yes.
of the order?
It is, my lord.
Yeah.
And let me explain and how it fits into...
So while I must accept that it's a fact,
Yes.
what you urge me to accept, that the order was final in effect,
Yes.
and the filing of the application for leave to appeal suspended.
Yes, that's correct.
And the irrationality you impute to the JSC is that it just didn't appreciate
Didn't recognize that fact, among other things. My lord, your lordship is making my job much easier. Let's go there, because that's the third interpretation point, as it were. I'll deal with it very quickly. What we are saying, my lord, and this is again, I've dealt with this section 18 things many times at different levels, and there are always these common problems around it. Remember, the difference between us and the respondents is that this is an 18.2 event, and we say it's an 18.1 event,
Yeah.
as your lordship just summed it up.
Yeah.
Now, these are the simple reasons we say it's an 18.1 event, my lord, is your lordship will find the actual wording of the, of the sections in our notice of motion and our founding of the, I think it's 02-60 something.
Yes, I have the act in front of me. You don't need
Oh,
to.
perfect. Okay, fine. Let me also just rather do that. Yeah. So let's start at 18.2, my lord, and just read it together. So 18.2 says, subject. Okay, the two things define whatever the default position is.
Yeah.
Subject to subsection 3, unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision that is an interlocutory order, not having the effect of a final judgment, which is the subject of an application for leave to appeal, is not suspended and pending the decision of the application or appeal. Now, all we're saying, my lord, we concede that when we wrote the letter on Monday, this Monday, the applications for leave to appeal were not in. But we obviously indicated that they're coming, and as soon as they came, we sent them. In fact, I think, if I'm correct, subject to correction, by the time the JSC had its meeting, we had already lodged.
Yes, well, in its letter, the JSC refers to section 18.2.
Yes.
And so I think...
So they must have, yes.
I think they must have
Yes,
appreciated that either their decision had to be taken on the basis that the appeal
Of
would definitely
18.2.
come, or that it had already come.
Absolutely.
Yeah.
As the court pleases, my lord. And I want to kill two birds with one stone, as we discussed this, my lord. The first bird is to answer your lordship's question as to why we're saying it's an 18.1, 18.2. The second one comes from what your lordship's remarks just now, which is why we assail the JSC decision on this point. In other words, we're saying on this point they made a material error of law. And as your lordship knows, material error of law leads to irrationality or illegality.
Well, if they made an error that's as basic as you say they did,
Yes.
then that definitely
That's
renders
it.
their decision
Yes,
irrational.
absolutely.
And there might be some highly complicated
Explanation.
terrain in which an error of law
Yeah.
doesn't lead to irrationality,
Absolutely.
but I can accept for the purposes of this case, it does.
Yes,
Yeah.
absolutely.
If there is such an error.
Yes, if a big if. Yes. Thank you, madam. Now, so since we're on the same page on that, my lord, let me then explain this in simple terms. So we say there are two exceptions which are contained in 18.2 that assists us in our interpretation.
Yeah.
The first is the word interlocutory order. A decision that is an interlocutory order.
Yeah.
Many people read that to mean an interim order. But that's not the same thing, because as your Lordship knows, there are interim orders and there are interim orders. And that has been explained in a case that I did called Libashe, that everyone knows. I think it's the most recent.
The section itself appreciates that there may be interlocutory orders of final effect, because it only applies in circumstances
Absolutely.
where there's an interlocutory order not having the effect of a final
Absolutely.
effect.
Yes, and that's the second point.
Yeah.
So we're saying, my Lord, forget about the final effect for a minute.
Yeah.
If it's not an interlocutory order, even if it had or didn't have a final effect, that would favor us. But secondly, as your Lordship correct, let's assume we're wrong on the interlocutory order thing. If it has final effect, then it's excluded as well. Now, so we say on both legs, my Lord, that favors us. And every lawyer, and I'm sure my learned friends will be no exception, will accept that if there's an application for leave to appeal and you can discount 18.2, then by default, then it's, you are in 18.1.
Yeah.
So that's our argument. So our argument is simply this, my Lord, that because of the operation of those two exceptions, we're in the 18.1 land. And once we're in the 18.1 land, contrary to what all our learned friends are saying, no, why, even on alternative relief, why don't you go to 18.3? No, it's them who should go to 18.3. They are the ones who have a duty, if they don't want to the order to be suspended, to do an 18.3 application. Thank you, my Lord. I'm not going to belabor that point anymore. The court.
Yeah.
I'm not saying the court agrees with me. It understands.
I have the point.
Yes.
Thank you.
Thank you, my Lord. So that's a huge interpretational point on the one hand, but secondly, an attack on the reasoning process of the JSC. So I want to do it one by one. Now, my Lord, if your Lordship allows me to then, I'll do another double take to demonstrate to your Lordship that what we are talking about, while accepting for the purpose of this, that what your Lordship correctly called the fact of that order, that we accept. But what this case is all about is about the constitutional effect or the constitutional impact of that order. We're not attacking the order. We're simply saying its constitutional impact results in the JSC as matters currently stand being improperly constituted. That's really all. It's that simple.
And that's the second basis on which you attach
yes.
the JSC's decision. You
Absolutely.
JSC ought to have appreciated that it would be improperly constituted
Absolutely.
if proceeded.
Yes, and if you look at their letter, my Lord, you will see that actually is the main material error of law, as it were. For them, the main.
They essentially say you're still Dr. Hlophe is still a member of the JSC.
So what's the problem?
He just can't come.
Exactly.
Yeah.
Well, that's what they're saying. Whereas, in reality, my Lord, if we are correct on this point of the constitutional impact, and let me, if your Lordship forgives me, let me just quickly get rid of no, I'll deal with it when we deal with the exclusion.
Yeah. Yes.
Let me stick to the constitutional impact. So if the constitutional impact of that valid order of the Western Cape High Court is to create an unconstitutional situation, a situation that is inconsistent with the Constitution, if I succeed in persuading your Lordship that the situation created is inconsistent with the Constitution, then your Lordship has no option, but no option, because Section 172(1)A says you must. Once I can show that constitutional inconsistency, your Lordship must declare that conduct to be unconstitutional.
Well, we get to the same result if I concluded that the JSC had acted irrationally.
Yes. No. Actually, my Lord,
that would be in breach of Section 1C.
Absolutely. In fact, my Lord, and I'm glad your Lordship asked that question, because again, it's misunderstood. That's the difference between Section 38 of the Constitution and 172. The Lordship has hit the nail on the head. Some people confuse the two. Section 38 deals with an infringement or threatened violation of a right in the Bill of Rights, right? But Section 172(1)(a), as your Lordship has correctly summed up, deals with the inconsistency with the Constitution, not just with the Bill of Rights. So any section of the, so that's the difference which is usually misunderstood. And your Lordship is 100% right. Whether it's Section 1C or Section 200 or Section 300 or whatever, if you are able to I know there isn't.
Yeah.
Yes. No, Lordship is definitely on point. But I'm exaggerating for effect.
Yes.
So I'm saying, my Lord, whatever section of the Constitution is violated, or once that is established, of course, that's the gateway. Once that is established, then and the constitutional writers, my Lord, were it was a deliberate way to phrase 172(1)(a) as opposed to 172(1)(b, because that's what constitutional supremacy is. We can't say the Constitution is supreme, and then we say a court has a discretion.
Well, it seems to me the 172 duty is to declare any conduct that is inconsistent with the Constitution to be so.
Absolutely.
But then there's a wide remedial discussion about what a court does.
What to do, yes. In fact, sometimes the court may do nothing. but what a court is enjoined to do constitutionally, it's a duty, a constitutional duty, is once established, it must declare. And that has been said, my Lord, if you, and your Lordship, allow me 1 minute to digress as to why that is so. One is constitutional supremacy, we've dealt with that. But the second one, which is always forgotten, is something called the doctrine of objective constitutionality. Now, that's just a lot of big English. But what it really means, my Lord, is that when the court does that and makes that declaration, it is not declaring the conduct of the JSC to have been unconstitutional last week or on Tuesday when it had a meeting. It's declaring that that conduct is unconstitutional since 1996.
Yeah.
That's so it's...
Unless the retrospectivity is...
Absolutely, yes. That's why sometimes the court then ameliorates that, yes. So it is that serious. That's why we have something, my Lord, another misunderstood concept called the Gijima principle. And it goes like this. Once a court has a 172(1)(a) issue in front of it, it must, even in the face of unreasonable delay, in the face of mootness, and all these other niceties, that court, according to the Gijima principle, still has to grant the order. Why? Because all these niceties notwithstanding, a court cannot go back to chambers to put it, to demonstrate it, and leave an unconstitutionality sitting on the table, simply because it took me 6 months or whatever. It's that serious, because that implicates the supremacy of the Constitution. Now, that then puts a burden on me, my Lord, to convince your Lordship that there is indeed an inconsistency with the Constitution. Not in the full court, in the conduct of the JSC, yes.
So the two points you've made so far are that the JSC misconstrued the effect of the order.
Absolutely.
And that it misconstrued the impact
of Section 18.
Of excluding Dr. Hlophe from the proceedings.
Yes.
Is there any further point? Yes,
and Section 18, you remember we just discussed.
Doesn't that really collapse back into final or interlocutory effect of the order? If the JSC thought that the order was interlocutory in effect when it was only final, when it was actually final in effect, it doesn't. The issue about whether 18.2 or 18.1 or 18.3 apply falls into that misconception, doesn't it? No, my Lord, with the greatest respect. If it's much more serious than that. It is that, of course, but it's more serious than that. It has two serious impacts. It says that the JSC, when it was given, remember the JSC is an organ of state. So it's the best way to put it, sorry to interrupt you, but the better way to put it is your case is that the JSC failed to appreciate that the order was suspended by the application.
Absolutely. And in doing so, as we discussed earlier, committed a material error of law. And if the JSC's decision is irrational, then the Lordship has no option but to...
And then there's the constitutional impact of proceeding in Dr. Hlophe's absence. Is there anything else that in your submission vitiated the rationality of the JSC's decision?
Yes. Yes, my lord. Okay, let me put it this way, my lord. If your Lordship allows me, I won't answer the question directly. I just want to start at the end. One of the giveaways, and we say this, unfortunately, your Lordship hasn't seen our reply, but your Lordship will find in our reply that one of the things we say is that one of the giveaways that the JSC's decision was irrational is something that is said by one of its commissioners, Mr. Hlophe, in his supporting affidavit.
Yes.
In that, he actually says, my lord, your Lordship will find that in section 6, page. Anyway, my lord, let me paraphrase to save time. Your Lordship will take your Lordship time. But this is what
I have it here. It's 06-287.
287.
Yeah.
Yes, my lord. All right, I'll get to it. Let me just paraphrase. Your Lordship will read it in well, there's no good time. I was going to say in good time, unfortunately.
No, but I have already read it.
Yes.
So if you just advert to the part of it, just while we're on this point, I still don't see the replying affidavit on case lines. If someone on your team could sort that out.
Yes, my attorney is here.
Yeah.
Can you just reload it?
Thank you. And if you can't sort it out for any reason, just email us.
We'll give you a hard copy. In due course.
Yeah.
Now, there's your Lordship, again, I won't bore you with all these authorities. Your Lordship will know there are cases, the line of authorities, National Lotteries Board, there's a case of Zuma, this has the DA and so on. It's all in our heads. But the gist of those cases, my lord, is this. The first one was Kachalia JA, I think the second one was Wallis JA, and the other one is NAFSA ADJP. And they all say this paraphrased. When you give, and we're now, my lord, busy really scrutinizing the letter of reasons that is given by the JSC. And I'll show your Lordship that that letter is not worth the paper it's written on. We've dealt with the Section 18 thing. Now, in this phase, my lord, that line of cases says, makes the following simple proposition. If I do something, and then my learned friend, I'm an organ of state, says, why did you do the something? And give me reasons. Then I give her reasons A, B, C. Then she challenges the
This is the reasons that you gave at the time.
Absolutely.
You can't supplement your reasons.
You can't, and in the answering affidavit. Yes, that's the principle.
Yeah.
So what Justice Kachalia called the ex post facto rationalization in the answering affidavit must just be chucked out. It doesn't count. Yes, your Lordship got the point.
Yeah.
So, contrary to that noble principle, the JSC tells us that no, after we gave you the reasons, we then went and did some research, and Mr. Hlophe says, I then went and spoke to each division and what have you, and then they give us a litany of reasons why the order should not be
well, aren't they just trying to talk about the balance of convenience?
Yes, no, I know, my lord.
I'm not sure they were being proffered as considerations that were present to the JSC's mind when it took the decision not to postpone.
No, my lord.
What they're saying is the balance of convenience doesn't favour you.
I appreciate that, but well, then that's even worse, because if that is so, then again, it's that thing of elevating the alternative. Then we must chuck it out for that reason, because it's got nothing to do with the real case, which is the declarative.
Right.
Right. if and only if we ever get to the alternative relief, then all that might be relevant. So otherwise, all that is just completely.
But I certainly,
and I appreciate
you can certainly take it from me for the purposes of your argument, but I don't, in order to consider whether the JSC's decision was rational, it would be a mistake to ascribe the facts given in Mr. Nlukai Toby's supporting affidavit to the people who made the decision, or to say that to find as a fact that all of this was present to their mind at the time they made the decision.
That's a hallelujah.
Well, what was present to their mind is what they told you.
Absolutely. No, then we're fine, my lord.
In their letter.
Yes. No. Then we're done on that one. I promise you, I won't even breathe a word about it. Yeah. So if we then go back to the letter, you'll find that, my lord, irrespective of the, lawyers can dissect these things, but really there's one reason in that letter, and it is that the JS, or rather, the full court did not kick Dr. Hlophe out. That then takes us, my lord, to the cases, to the authorities. The authorities.
Yes. So sorry. Just to sum up, so I know where you're going.
Yes, my lord.
On the basis that the question of the rationality of the JSC's decision must be determined by assessing the reasons they give in the letter.
Yeah.
You really only want me to find that paragraphs 2.1 and 2.2 of the letter are just wrong, and that renders the decision irrational. Yep.
And not, as your lordship knows, and I don't want my learned friends to think, and I know your lordship that's not what your lordship means. But when we say wrong in this sense, we don't mean in the appeal sense.
No, there's
we
been
mean
a
material error of law. Yes.
There's been a misconception of a basic.
Absolutely.
Your case is that there's been a misconception of a basic factual or legal proposition that has tainted the rationality of the JSC's decision, and the two respects in which you say there's a misconception are essentially spelled out in 2.1 and 2.2 of the letter.
And the preamble, my lord, that's where they talk about section 18.
Yes.
Which we have covered. Yeah.
Yes,
so
okay.
if you want to be generous, my lord, we say there are three reasons they've given. It's the 18 2 reason.
Yeah.
The second one is the non-setting aside of Dr. Hlophe's membership. And then the third one is really the same as the second one, where they say the full court has interdicted from participating in the process. It's expressly found that Dr. Hlophe's absence would not render the JSC's decision operational. That's just wrong. That one is wrong in the true sense. Let me tell you why, my lord. Because your lordship knows that at paragraph 56, I think, of the judgment, that last one is just, it should take 1 second to deal with it. Yes, it's paragraph 56, 02-66. What the JSC, I won't ascribe any deliberate intent to it. Let's say it's a material mistake here. They said the court there said the respondent's submission that the JSC would not have a quorum in order to take a valid decision if Dr. Hlophe is interdicted from participating in that forum is incorrect. Well, I can tell you, my lord, for free that we never made that submission, but that's not for you, that's for the appeal court. Yeah. But assume for now, for present purpose, that we did. The court then goes on to say that in the premier case, the issue was whether the premier's attendance was necessary, and the court concluded that it was, which is correct, by the way, and we rely on that very heavily.
Yes.
Yeah. Now, the mistake that everybody makes is to conflate two simple things that are not the same: quorum and constitution or composition. We accept, again, for the avoidance of any doubt, if anybody wants to accuse us of saying the absence of Dr. Hlophe is going to affect the quorum of the JSC, well, I'm saying here loud and clear, no. We accept implicitly that the quorum will not be affected. What is affected is the proper constitution of the body, in our respectful submission. Yes. That's all. And those are two unrelated things. So again, when the JSC then says in its 2.2, my lord, that the High Court found that it doesn't matter. Well, you can just scratch out 2.2 because we agree, but that cannot be a reason to deal with what we are raising, which is composition. Yeah. So that's why I say in reality we are really left with 2.1. Now, my lord, let me just make another point, which whatever I do, I must not forget. And this deals now with what I was saying are the authorities. Yeah. I'm now on the second leg. The interpretation points I've dealt with all, my lord. On the second leg, which is what we call unjustified exclusion. Yeah. This is the case of the other side, and I'll show you how fallacious it is. They say, and you can see how clever lawyering constructs this argument. So they say, yes, we accept that in the SCA has twice said in Premier and in Bar Council that the composition of the JSC is all and for one. Everyone must participate in the decision. They say we even accept that principle comes from the old cases, Ski Road and so on, and the lex impossibilia principle and so on and so on. But they say, but the problem is that MK and Dr. Hlophe have forgotten one thing, which is that that court made the qualification that it must be an unjustified exclusion. And then they say, how can it be an unjustified exclusion? Because there's a court order. Very attractive argument at face value, but it is absolutely wrong. You see, this court is bound by the SCA decisions. And to the extent that the SCA, even if there was some discrepancy between the SCA decision and the full court decision, this court would obviously be bound by the SCA decisions. Yeah. So I'll concentrate on them. What was said, my lord, in both cases completely assists our case, my lord, and shows that the JSC's reasoning was completely flawed. What was said in the let's start with the Premier case. There, my lord, Helen Zille, who now has flip-flopped and taking a different stance in her affidavit, was saying that the JSC was not properly constituted because she was not in the meeting in terms of I think it's 1K. Yeah. And she then said, well, for that reason, because firstly I was not there as the Premier, but also my alternate was not there. Therefore, the meeting was not properly constituted. And the SCA, for good reasons, agreed with her. And but now she wants the other side of the coin. The SCA agreed with her on the following basis, my lord. The case, and I must concede this, is not on all fours in the following respect, my lord. The gravamen of that discussion was about 178.6, as your lordship knows, the majority or no majority. But in the course of that, the court did two things. It reaffirmed the principle, and that's why Ms. Zille won the case. It reaffirmed the principle that everyone must be there. But it also left open a very important question. You'll remember, I think it's paragraph 21 of that judgment, my lord. Yeah. It was raised by, or rather the court accord, Jones J, had also made Ms. Zille to win the case on another aspect. And that aspect was this. Ms. Zille had raised the following point. She said, One of the advocates that are in 1E had not yet been appointed, and therefore the body was not properly constituted, and she was right, of course. Again, nothing to do with the quorum, but the constitution. And the court said, because we have already found that she's right on the primary ground, we're going to leave open the second one. So which means, as we speak, that finding of Jones J, that even on the second leg, she was supposed to win, stands. Or at least it was not overturned by the SCA. I can't put it higher than that. Now, so what does that do, my lord? Two things. One, we must remember that our case is stronger. I'll tell you why it's stronger than both the Bar Council case and the Premier case. In both of those cases, my lord, the so-called absent member of the JSC was somebody who was allowed to have an alternate. In this case, there's no such, and that's the kind of thing Mr. Ngalwana was alluding to. The delegation, the delegation of 6 in 178(1)H must be as it is. It's a half a dozen, or it's all or nothing. They are not allowed to even have alternates, unlike all these other people. The judge, the chief judge, even the judge president and the premier and so on, those people are allowed to have alternates.
Yeah.
But here, it's you have to attend personally, or you must not be there. So that's a crucial distinction, which makes this particular case distinguishable in the positive sense, in that it's even...
Notionally, the National Assembly could elect someone else, but then they'd be reconstituting
absolutely
the JSC.
the entire squad.
They wouldn't be giving Dr. Hlophe an alternative.
Absolutely.
Yeah.
Absolutely, my lord. Your lordship, that gets rid of something else I was going to say about alternates. Yes. In other words, even this, there's this thing that gets bandied about, oh, what's the problem? MK could simply substitute Dr. Hlophe and put somebody else. No. How? Under what basis? On which constitutional basis? There is no such constitutional basis. The lordship is correct. The only way you could ever achieve that would be to take the entire resolution back to the National Assembly and then have a new delegation, which may or may not include Dr. Hlophe and all that. And that's why in our letter we said, even if we don't accept that can be done.
I think it's common ground that the National Assembly would have to hold the election again if it wanted to replace it.
Yes, no. But it's not. No, it's not, my lord. All these parties are saying they don't know what we are complaining about, because MK can simply somewhere put somebody else. But your lordship is quite correct. The only way you could do that is to revoke the designation. And that's another facility that is used by FUL in particular. They suddenly now sometimes you surreptitiously do something. Suddenly they talk about designations. There's no designations. It's a designation of it. So that designation would have to be redone. And that, my lord, to be quite honest, was all we were asking from the JSC. We're saying, even we don't agree that you can substitute, but for the present purposes, say you can. We say to them, the Parliament is in recess. The thing is starting on Monday, and even if that thing that substitution was allowable, it can't practically be done. So please postpone, and I'll even be more strict. I'll be much stricter than Mr. Ngalwana. 6 months, 3 months, 2 months, whatever it is. You could even say, okay, we'll postpone for a period of 2 months or 3 months. Within that period, this clarity must be sought. And obviously, we know our courts would accommodate. This is a big issue. The Part B must be expedited. And in that 2 or 3 months, the whole thing will be cleared up, my lord. So that's all we're saying. We're saying avoid all this litigation.
So a 3-month suspension to work out whether Dr. Hlophe can still be on the JSC.
Absolutely.
Not a 3-month suspension for you to choose someone else through the parliamentary process.
Even that, my lord, if you like. Let's say for anything. But we have to be honest to your lordship and say that our advice is that the so-called substitution is not viable. But for the purposes of this case, my lord, assume that it is. Assume that it's viable. So your lordship is quite correct. So we're saying three things. We're saying postpone for 2 or 3 months, pending one of three things. And again, even this is misconstrued. We say either and the lordship will find that in our notice of motion at 023. The final determination of the appeal against the orders of the judgment of the full court, your lordship knows what that means.
Yeah.
The second one, we say the final determination of Part B of the applications pending in the Western Cape. Let me pause there. Both of those things, my lord, can conceivably be done within a month or two. I mean, if everyone commits to it, quite frankly. Because the pleadings are there might be a bit of supplementation here and there and so on, exchange of heads. We all know case management could make sure that those cases, I don't want to be overly optimistic, ahead, let's say by November or early December. But the third one is even lighter, my lord. We say the final determination of the main application set out in Part BB. Now that case, my lord, can happen next week, quite frankly, and it can be done, because that case is about one thing only. It's about the exercise that your lordship and I have just done now, which is looking at that letter. Remember, BB simply says the decision of the JSC to refuse postponement in sitting at schedule on the 7th is reviewed and set aside. That's it. So it's only about the letter. And then here are the more important words, whichever occurs first.
Yeah.
In other words, next week, in the next 2 weeks, if we set down that Part BB, and this whole thing will be over.
Yeah.
Or if we go to the Western Cape High Court, the JP there, the acting JP, and say, please expedite either the appeal or Part B. Again, the thing will be done, let's say, longer than 2 weeks in that case.
Just to get a sense of where this notice of motion goes.
Yes, madam.
If I were to decide that the JSC's decision was rational and can't be set aside,
yes,
what is left of your case?
Yes.
Can you tell me that?
Yes, I'll tell you, my lord. If you decide that the JSC's decision was rational in the declarator sense. Yeah. Yes. Well, that's why, my lord, we have the alternative prayer. So we say.
But of course, Part BB would have to fall away.
It may and it may not. I'll answer that, my lord.
Right. Okay.
Yes. Yeah. But because remember there's a whole issue about Rule 53 and what have you in BB. But I'll work with your lordship. If your lordship were to say, as your lordship might be entitled to, if your lordship were to say, look, the decision, I'm not giving you the declarator because I agree with the JC's thing in the letter. And
I don't have to agree with it. I just have to decide it's rational.
Yes, that is rational. No, I mean it in that sense. It's like that right and wrong thing. Yeah. Then your lordship, the impact of that lordship's order may or may not be to render academic assuming there are no appeals. Remember, it's a final order. Oh, by the way, let me clarify that, because this is said as if it's an insult, as if no. It is. Paragraph 2 is seeking a final declarator.
Yes.
There's no two ways about it.
That's how I understand it.
It's not they say, as JSC says, as we want them to believe that is interim. No, we don't want them to believe anything. So your lordship is quite right. It's conceivable that a granting or even a refusal of paragraph 2 might render the second part to be academic. But that's not important for the purposes of it's important for the second question that your lordship asked me, which is what happens then. Yeah. So that's the first thing that might happen. But what will certainly happen is that the prayer 3 will then have to kick in. And that's why prayer 3 starts with the words alternative to prayer 2. In other words, if you fail in prayer 2, then we say the interdict. And the interdict is asked for, and let me get into that, my lord.
So your prima facie right that you assert on when you ask for an interim interdict is more extensive than the right to a rational decision from the JSC. Is that what you're saying?
Yes, my lord.
So
and
you rely on other rights?
Yes, and all these things about, the courts are going to fall apart and what, they then come into it. And your lordship would do.
Well, that's because it's an interim interdict and the balance of convenience is relevant.
It comes exactly.
But the whether or not the courts are going to fall apart.
Yeah.
So what other than the right to a rational decision from the JSC, what rights?
Relief we seek. Okay.
What rights do you rely on for the purposes of the interim interdict? I suppose is the question.
Yes, my lord. Can I, if your lordship allows me just to do this first?
Yes, please.
I'm going to address that question of the alternative, but let me just wrap up the first part, my lord. If your lordship grants paragraph 2, then your lordship obviously then will jump paragraph 3.
Yeah.
And then what we want your lordship to go, then to go to paragraph 4, which is what I want to address there. So your lordship would then grant appropriate, just and or equitable relief in terms of 172(1)(b, which we discussed, and that is the May, and or section 38 of the Constitution. And here's the important part, my lord, including the interdictory relief set out at prayer 3. In other words, your lordship may, in the wide discretion of just and equitable remedy, the lordship might say, don't sit on Monday. But the lordship could say something else. The lordship could say, as Mr. Ngalani said.
Well, I understand your submission to be, if I grant paragraph 2, that's a final order.
Yes.
I am then at large to exercise an equitable discretion.
Absolutely.
To make an appropriate order
that
may include interdictory relief or not.
Absolutely.
To give effect to the consequences
of the
declaration.
That's correct. That's all, my lord. So that's the main relief. Dusted, done and dusted. Now let's come to your lordship's question. If all of that doesn't materialize, then your lordship say, well, then what? Then we say, my lord, that there are 3 grounds, and I'm going to eliminate 2 quickly now. There are 3 grounds upon which your lordship could still grant the interdict. One is that your lordship would there's a case called Hoërskool van Warmelo.
Yes.
We've loaded it up and it's referred to in our heads.
Right.
In that case, my lord, and also this was reaffirmed in the impeachment case that we did I even think your lordship might have been there. But in the impeachment judgment, your lordship will remember that the...
So who were we impeaching?
The first respondent's president.
I don't think I was there.
Yes, maybe it was the UDM case, yes. But, my lord, in that case, the Constitutional Court affirmed this principle of Chapter J of Hoërskool van Warmelo. Actually, in another case, I was trying to say that matter was wrongly decided, but it is the law. Here's the law, my lord. The Van Warmelo says that the conception that in the heads, no, but why is it in our heads? The passage quoted in our heads, your lordship will see it. Paraphrasing says this: it is not true that you can only do 172(1)(b) if you find in our favor in 172(1)(a). Yeah, it's in paragraph 19, page 19-12, 112, paragraph 122 of our heads, and it reads as follows. I won't read the whole thing. It says the remedial power envisaged in section 172(1)(b) is not only, and the word is only, is not only available when a court makes an order of constitutional invalidity of a law under conduct under section 172(1)(a). So, Musanaka DCJ in that matter.
Well, it's when deciding a constitutional matter within my power.
Yes.
And that obviously goes much further than those 2.
Absolutely. Yeah. All of us, until that point, we thought the key to 1721B is that you must have the declarator in 1721A. But Musaneko DCJ said no. The wide powers of the court are not confined to, you may not get your declarator, but the court can still. So that's the first basis upon which this court, my lord, could grant the, let's call it the relief in four, including, the court could say, for example, I'm giving you this interim relief, but it's for 2 months. And in that 2 months, you must, as what Mr. Ngalana was saying, in that 2 or 3 months, you must have done everything, and you must come back here if
I've got that. What I'd like to zero in on is if I were not for any reason to be convinced that you're entitled to paragraph 2, is there any other basis for an ordinary interim interdict? What other prima facie rights do you rely on?
No, my lord.
Do you or don't you, I suppose, is the question.
No, my lord. That's why I'm raising this case. I'm saying, even if your lordship is against me on paragraph 2, on prayer 2, your lordship on the authority of Van Varmelo is still able to grant 172.1b relief. And on that basis, that 172.1b relief may or may not include the interim order that looks like 2. It might be something else. That's where I was. I said, your lordship.
But I'd have to find some sort of
constitutional
breach or
yes.
Prima facie right.
Absolutely.
A violation, prima facie violation of a right.
Yes. No, my lord, we're together. I'm simply saying, I'm just registering the point that it is not totally dependent on 2. Okay, put that aside. Your lordship is then right. Now, if we now then confine ourselves into the let's call it the interdict, whether that interdict comes from 172.1b, whether it comes from section 38 appropriate relief, or whether it comes from the common law, for the purposes of this discussion, it doesn't matter. The only thing is that, my lord, if it comes from 172.1b, your lordship's discretion is much wider. If it comes from 38, it's even wider, because Forze, your lordship will know, Forze says that appropriate relief really means the court can even fashion new remedies that have never been seen under the sun.
As long as you don't reward punitive damages. That's
unfortunately, for some of us.
Or constitutional damages, except in the most extraordinary of situations.
It is more than extraordinary. Forze was my first case in the Constitutional Court, 1996. But unfortunately, the court said no constitutional damages. Subject to that, yes, Forze says that. So your lordship's hand, in terms of 172.1b or 38, is really that wide. Of course, when it comes to the common law remedy, then it's a little bit more restricted, because then you have to take into account outer and so on and so on. All the things that Mr. Ngalana was dealing with. Although, in my respectful submission, even on Mr. Ngalana's submissions, which he eloquently made on the common law relief, we should succeed. But a fortiori, if that is even remotely possible, then certainly on 172.1b and 38, we must succeed. But let me zero in on your lordship's question. You see, in this realm, my lord, my work is much easier. Because once we are here now, I no longer, as I heard now, just now, have to say to your lordship, Dr. Hlophe's Section 19 rights were violated. What are Dr. Hlophe's Section 19 rights? His right to participate in the activities of a political party of his choice. That's obviously been limited by the non-postponement decision, and that can be debated. MK's right to have its member participating in the JSC, another Section 19(1) right, that's obviously also been prima facie at least infringed. Dr. Hlophe's dignity right to work and do and be a meaningful citizen that does self-worth will be implicated. Dr. Hlophe's Section 34 rights, my lord, to appeal, which goes to the whole debate we've had about Section 18. So I could do a catalogue of Dr. Hlophe's rights that will be implicated, including his right to have a rational decision from the JSC and all that. All that my burden is lighter in the following way, my lord. Now, all of a sudden, all I have to convince your lordship is that those are prima facie rights open to some doubt.
Yes.
Whereas in the previous section, I had to show your lordship that those were actual rights.
Yes.
So now it's even easier. It's plain sailing, because your lordship could say, well, I'm not sure if the right to participate, but you know, it's open to some doubt. But your lordship would still have to grant the interim relief. Couple that much lighter burden, my lord, with everything that Mr. Ngalwana has said about, for example, the impossibility of removing a judge who would be unconstitutionally appointed. All sorts of things, my lord, and I don't want to be alarmist. The kind of litigation that could come from the people who lose, not lose, who are not appointed next week.
Yes.
Because they can say, oh, well, this thing was improperly constituted, and also, your lordship gets the point. There can be a whole lot of things. And that's why we said in our letter, please, JSC, postpone for a short period to avoid a litany of possible litigation. The mind can go as far as it can as to what kind of chaos could happen. And that's what we call if the constitutional crisis that has been precipitated is allowed to continue.
Yeah.
So what's wrong with that, my lord? What is wrong with saying, please postpone for a month or two, put everyone on terms, and then come back and report to the court, so that all of these things, so that Dr. Hlophe's right to participate is protected, my lord. His Section 19 right.
Could you just address me for a moment on the proposition that those rights have been limited by the full court, not by the JSC?
No. Yes, thank you, my lord. No. That's a big mistake.
It's going to be important for your colleagues to hear what you have to say about that.
No, of course, because we know it's coming. That's a fallacy, my lord. What we are here about, as I said at the beginning, is not to assail that court. What we are here about is to assail the JSC's decision. The exclusion of Dr. Hlophe from the meeting next week is not as a result of that court order at this stage directly. It is as a result of the decision of the JSC unreasonably and irrationally not to accede to the postponement. That's a crucial point, my lord. And
but this is why I wonder whether the additional relief you seek doesn't ultimately collapse back into the proposition that the JSC was irrational.
No. Of course,
because the JSC's position is that it's bound by the full court's order. The full court's order placed Dr. Hlophe under restraint.
Yes.
If that order does engage the constitutional rights you rely on, then it's the order that has stopped Dr. Hlophe from going to the JSC, and the order binds the JSC.
Yes.
So either the JSC is right to draw that conclusion, rationally to draw that conclusion, or it isn't.
Yes.
If it isn't, then it's irrational and paragraph 2 follows.
Yes.
But if it is, I wonder how you can impugn the JSC as having violated any of Dr. Hlophe's rights. No,
my lord. Please, lordship, just if you don't hear anything I'm going to say, just hear this.
Well, I've heard a lot, and I will listen. I'll listen to what you're about to say as well.
This, my lord. Yeah. Remember only this.
Yeah.
Only this. Why we are in this court before you, my lord, this sunny Friday, is because the Judicial Service Commission refused to accede to a postponement decision. Now, and we're saying, my lord, what excludes Dr. Hlophe, okay, put it this way, my lord, let's flip it. If the JSC had acceded to the postponement decision, Dr. Hlophe would not be excluded from the sitting next week.
Yes.
Okay, so now, and if the JSC had acceded to the postponement decision, let's say maybe even with conditions, what we're asking from the Lordship, and say, okay, but we'll only give you 2 weeks or 2 weeks or 2 months or whatever it is, Dr. Hlophe would not be excluded from the sitting. So the proximate cause of Dr. Hlophe's exclusion from the sitting next week is the JSC's decision. That's it, Balodi. It's not, of course, if you want to do the normal causation thing, you can say the sine qua non is the court order. But the real cause is the JSC decision. Yes.
Thank you, I have the point.
You got the point. Yeah. And my Lord, let me then quickly go to paragraph 21. No. Because we don't have time, I'll go to paragraph 35 of the Cape Bar case. I'll
35.
The Cape Bar case. Yes.
Yeah, let me just get there.
Yes, yes. Acceptance of counsel's argument. This was now a criticism of the JSC council when they still thought composition means everyone must sit. But they've also changed their stance. It says, acceptance of counsel's argument for the JSC that matters relating to specific high court could be determined in the absence of the judge president of that court and the premier of the province concerned, or an alternate designated by both of them, which would be in direct conflict with the provisions of section 171K. What is more, I believe...
Just give me the paragraph number.
35, I'm sorry.
35,
35,
yeah.
yes. Yeah. I'm now in the middle.
Thank you.
Yes. I've just read the first long sentence.
Yeah.
It says, what is more, I believe that it is clear from section 178 of the Constitution that the JSC has been created in a structured and careful manner. Its composition obviously sought to ensure that persons from diverse political, social, and cultural backgrounds representing varying interest groups would participate in its deliberation. And here's the killer, my lord. Any interpretation of section 178 which would allow decisions of the JSC to be validly taken without the unjustified exclusion, there's that expression, of one or more of these interest groups would therefore negate the very essence of the constitutional design. That is what we are here about. That careful constitutional design will be completely negated if there is an unjustified exclusion. And since we have already agreed about the approximate cause, the unjustified decision, unlike what my learned friends are going to tell you, is not the court order. Because they're going to say, oh, well, how can it be unjustified because there's a court order? No. The unjustified exclusion of Dr. Hlophe is the irrational refusal by the JSC of his participation. And therefore, on the authority binding upon you, my lord, of the SCA, your lordship has no option but to find that you cannot allow a situation where the careful design of, remember the careful design is even worse in this case, my lord. Normally they say 2 advocates, 2 attorneys, what have you. Here the constitutional drafters went further. They said 6 members of the NA, of which at least 3, minimum 3, must be opposition. So the Constitution is even more prescriptive. That means, my lord, all 6 could be opposition members, but at least 50% must be. Now we have a situation where it's 40%, even if Mr. Ngalwana's interpretation is wrong. We now have 40%, so that's constitutionally repugnant. Let alone Mr. Ngalwana's point, that you might even have the, unjustified inclusion of the other 5, which makes it even more unconstitutional. So the SCA authority that is binding on your lordship, you'll remember in that case court, by the way, was also a bit not comfortable with this, but it said, but we're bound by Premier. So similarly, your lordship is bound by both Premier and Bar Council, and your lordship has no option but to find that the unjustified, irrational refusal of the postponement by the JSC is the is the problem that your Lordship must undo. And your Lordship must simply do, if to put it in colloquial language, your Lordship must simply do that which the JSC should have done, which is to say, okay, we'll postpone for a month or two or whatever it is, but this and that and that and that must happen, so that there's no threat of any constitutional crisis. Everyone is happy, nobody's excluded, nobody goes to court to do anything, and within that limited period, everything is done. And I can guarantee at least one of the three things, which is the Part BB, as I said, my Lord, can happen in a matter of weeks. The others, I'm prepared to concede, can happen in a month or two, because there'll be exchange of heads and what have you. But on the basis of the relief that is sought here, your Lordship has to, even if your Lordship is not with us on the declarator, and I cannot see how your Lordship cannot be with us on that, but even if your Lordship is not, your Lordship, we implore your Lordship with the greatest respect to simply then fashion, quote unquote, that remedy which will leave nobody, there'll be no chaos. Of course, there'll be inconvenience to all sorts of people, but as I don't want to repeat Mr. Ngalana's submissions, but the balance,
yes,
on balance, that inconvenience would favor us. My Lord, those are our submission. If there's anything else, I will deal with it in reply. But in sum, we say interpretation of the court order of Section 18 of Section 178, and we say if you interpret those three instruments correctly, then it is in our favor. And then we say, give us the declarator for the reasons that have been granted, and then paragraph 4. But we say if we are wrong for some reason, then we have the lighter burden in terms of the alternative prayer. As the court pleases, my Lord.
Yes, thank you,
to your Lordship.
Thank you, and thank you for just about keeping to time.
Thank you, my Lord.
I'm going to take a 15-minute tea adjournment, come back at noon, and I'll hear from Mr. Mainiche.
As court pleases.
Yes, thank you.